I'll just talk a little about the Information Commissioner's Office. Our mission here in the UK is to be the independent authority within the UK set up to uphold information rights in the public interest, promoting openness by public bodies and data privacy for individuals. Essentially what that means is that we cover legislation that promotes openness by organisations who individuals have the right to see data that's held by public authorities here in the UK, and also to have their data protected. And the Data Protection Act covers those areas. We're very much an outward-facing part of regulation and government within the UK. We do enforce and regulate those laws that I've said, namely Freedom of Information Act, Data Protection Act, but also the Environmental Information Regulations and the Privacy and Electronic Communications Regulations here in the UK as well, which they cover the use of direct marketing and electronic marketing. And so we have this legal framework here that organisations are required to work within when they are processing personal information, and when their processing would effectively have an impact on individuals and the privacy of individuals. We do this in various ways by providing information to both individuals and organisations to be as open as we can, to provide organisations with an element of knowledge and understanding about how the laws are set up and work here, so they can hopefully go ahead and process data in a way that is compliant. We'd much rather see organisations given the opportunities and the right tools and information to go away and to go away and process data in a compliant way than we would to go to enforcement action where we can issue fines. We provide that information in a variety of ways, whether it's directly with large organisations or trade bodies, perhaps by meetings or at events that we attend, with several speaking events. So we can spread our messages far and wide in terms of privacy and what we would expect organisations to do when it comes to upholding information rights. We also adjudicate on complaints, and that complaints from individuals who've received sent complaints to us where they've got issues with organisations who they believe are processing their data in a way. Client will adjudicate on those issues, and we promote good practice in several ways, including those one-to-one meetings, and also to organisations on a wider footing, where we publish publish guidance, and guidance is available on the ICO website on all of the legislation that I've talked about. Some of it's pretty complex to interpret, and I think that organisations find the guidance that we put out there very useful in terms of practical implementation of the Data Protection Act, and those issues that come about from the new ways of sharing information. Obviously, we're seeing new ways of data being shared all the time, innovative ways of information being shared, and we're seeing that very much with the dawning of big data and information age, where much more information is available to use. We do have powers to enforce where we have to be robust with organisations, and I was just getting on to talk about the ICO powers and what we can do when organisations get it wrong, essentially, when the Data Protection Act is breached. And we can see this happen in many ways. The most obvious and I suppose headline-worthy way of information rights being breached is when we see data breaches involving information that's been compromised, lost, either through a hacking attack or because an organisation has been careless with that data and literally left it out in the public domain. So you may have noticed, you may have seen some of the sort of headlines. The ICO has issued fines, and we can issue fines of up to £500,000 for such breaches. We publish all of the detail about those fines on the website. So if you're interested to know what sort of things organisations are getting wrong and what those breaches attract in terms of fines, well, all that detail can be available, and there are a range of issues that can happen for breaches of all of the principles of data protection, which I will go into shortly, just so that you know what those are and how the law is set up. We can also issue fines for serious breaches of, I mentioned earlier, the Privacy Electronic Communications Regulations, or PECA, which govern electronic marketing. It's one of those big issues that we're seeing a lot of. Complaints to the ICO are very much up on that level of on that issue of privacy of electronic marketing and people receiving texts and email marketing when they haven't consented to that. There are rules in place here in the UK to prevent that from happening, based on a European directive, which anyone within Europe will have an applicable law covered by this similar directive. So that is that's something that we're seeing a lot of ICO enforcement action on, that clamping down on marketing and marketing issues. It's become a serious issue for us. We're constantly getting complaints in the hundreds of thousands per year for individuals that are receiving marketing in a non-compliant fashion, and it's something that we're really fighting for. Jurisdictional issues can be difficult when it comes to actually issuing fines on that, because a lot of organisations will be based outside the jurisdiction that the ICOs and based outside the ICO's reach. Nonetheless, we're working hard to ensure that there are meaningful ways for the ICO to issue fines for breaches of those regulations. And interestingly, just last week, it was announced by the UK government that it's actually going to become easier for the ICO to issue those fines of £500,000 when there are breaches of PECA take place. We also have other mechanisms available to us in terms of powers, be that enforcement notices or undertakings. That's a more informal ICO interaction with an organisation, either by we have the power to tell them to stop processing data in a certain way if we believe that it is non-compliant, or we can get them to sign an undertaking, which is essentially a public declaration signed by an organisation to say, look, yeah, we've got it wrong. We want to turn things around in the way that we handle data, and we're willing to sign an undertaking to show that we're going to go down that road. And the ICO will then look again 6 months down the line to check that undertaking and all of the things that the organisation has promised to do are in fact being complied with. We have audit functions, not least for public sector organisations where we have some powers of audit, but also we use that not so much in an enforcement capacity, but an advisory capacity, where we get the opportunity to talk to organisations directly about their data protection compliance. And that's often where there's a small or medium enterprise or an organisation that is struggling perhaps a little bit with with how they handle data. They ask for the ICO's advice, and we go in and provide them with either a one-day audit or advisory visit, or a two-day more detailed audit to find out what the issues are and where they're going wrong with their data protection. And there are criminal offences. Again, I stress we're talking about UK laws, of course, but there are criminal cases, not least the issue of blagging or unlawfully obtaining data. Many of you may have seen this in the press context with blagging or hacking of phones, but it's essentially illegally obtaining data. That is a criminal offence under the Data Protection Act. So the points here really are that we cover a range of privacy law. We are the regulator to look essentially at these very fundamental parts of privacy law and information rights law in the UK. And we have several powers to allow us to do that, to make it to make processing data an important element of what organisations do in terms of understanding the privacy, intrusions, and the issues that it could cause to individuals, many of whom are reporting their concerns to us. I mentioned that the Data Protection Act here in the UK is based on principles of processing personal data. There are 8 fairly straightforward and fundamental principles that I'm sure you agree with actually taken together are fairly common sense. So even I think when you're processing data in a jurisdiction or part of the world that doesn't have data protection law that is exactly the same as we have here in the UK, some of these principles really are common sense, and you would understand that an individual would want their data handled by an organisation that takes these principles seriously. Firstly, there's a general principle of fairness and lawfulness, i.e. the information has to be, you don't want to surprise people by the way that you're handling and using their information, and the way that you've gathered it needs to be lawful as well. It can't have been obtained in a way that is deceitful or breaks another law. And I mentioned blagging there. Illegally obtaining data is obviously not going to be a lawful way of processing information. I mention these principles because many of them will be challenged by the uses of big data, by new ways of operating and using information. And it's important just to highlight what those principles are at the outset in a broad sense, because what we're seeing with big data, and I'll go on to explain a little more about this, is that organisations are saying, well, look, the data protection laws actually really can't handle the new ways that information is being used. They're creaking at the seams. We process data in a very modern and innovative way now, and current data protection laws are simply not fit for purpose when it comes to that. Some of the data protection principles are fairly broad, and there's a reason for that, in that they need to be able to move with the times. But a lot of these arguments do have certainly some foundation. In fact, in Europe, the data protection laws are currently being viewed. Current Data Protection Act and these principles were first drafted in the 80s, but the latest version of the law that we've got was drafted in the mid-90s, and obviously we use data in very different ways now. We process user-generated content on a massive scale. We're starting to see a huge amount of personal data being generated by concepts such as the Internet of Things, where more and more data is available and being used, and it can tell us more and more about individuals. So the laws are in the process of being reviewed. It's a slight aside from what we're talking about, but I think it is worth mentioning, because what big data does is challenge the principles. We've heard it from industry. We can see that ourselves, and we're really interested to see how the new law evolves to take into account the new ways of processing and what it's going to do to processing here in Europe and within the UK, whether it's going to make things more restrictive or whether it's going to allow for more processing in the sort of modern way, let's put it that way. So those principles, just moving on, as I say, fairly common sense. I'm sure you can see that. Some of them will be challenged by the uses of big data, but what we would say in our approaches to big data are essentially that it's big data analytics. They're not what we would say games played by different rules. In other words, the data protection principles that that you've just seen there, they do still apply to big data, even though it might be more difficult to actually implement those with the new way that data is processed. If personal data is used, then the data protection principles apply, and it's worth mentioning that the Data Protection Act and the Data Protection laws in the UK relate to the use of data that is personally identifiable. A lot of what happens with big data will be outside the scope of the Data Protection Act, because you might be talking about information that's gained about meteorological research, for example, information about the weather, information about travel times, things that are anonymous, that basically don't involve the necessity to identify individuals, but they will fall outside the scope of the DPA. And so anything that involves personal data, in other words, information that an individual can be identified from and relates to them, then that will be covered by the Data Protection Act. And obviously a lot of what organizations are doing regarding big data will really start to focus and look at that concept of using personal data, because a lot of what you're trying to get to is an understanding about an individual. It's a marketing strategy, for example, or whether you're literally looking for sort of behavioral patterns, or trying to identify the risk involved in insuring an individual, for example. There are many different ways in which the continued gathering and processing of data and the sort of capabilities that you can get from big data will sort of really come into play and be very useful to an organization that is looking to find out more. Now, I'm not entirely certain what the general knowledge of what big data actually is, but it has been described as a new way of processing information in terms of what are called the 3 V's. That's volume, variety, and velocity. In other words, volume, much more data being used; variety, a lot of data being drawn together from disparate sources, whether that's user-generated content or information that's being provided to an organization by an individual, whether it's a flight manifest, for example, or information that's gained during the course of a sale. And velocity is the final V. It's essentially quicker and easier to start sharing information and using it in innovative and interesting ways. So that's what we're very generally talking about when it comes to big data. The debate around big data has been ongoing for some time. It's a sort of title that has grabbed a lot of attention, and I think a lot of organizations are slightly uncertain about what it really means for them, which has clouded the conversation slightly around the uses of big data. But what we tried to do at the ICO was understand what organizations meant about big data, so we could contextualize the issues in terms of data protection. And we produced a document. It's more of a sort of study paper, having interviewed some players within the industry here in the UK that use analytics and use big data. And we released around about 6 or 8 months ago our paper and our findings on that. And again, you can find that on the ICO website if you're interested to see what we found and what those concerns are in terms of data protection. I'll go through some of them now, but the report is available if you should want to follow that up. So the challenge really for organizations in with that context of sort of the legal framework and new ways of using data that can be gathered and used is for organizations to be a little more innovative in the way that they do big data and analytics. And that is to say innovative in terms of transparency, in terms of what they explain to individuals when they're going to use their information. And that's built around that key principle that I mentioned earlier of fairness, sort of the first data protection principle, in that to be fair, organizations have to be transparent with individuals, excuse me, and to build trust, particularly when you're starting to gather data that might tell you something about an individual, about their behavior, about their habits. It's important that you build trust with your consumers. We're seeing a lot of research out there that shows that, contrary to popular belief, privacy is not dead, and people do actually care about privacy. And we're finding in some cases individuals are more willing to deal with organizations who take their data seriously and protect that information or use it in a reasonable way and make clear that that's happening and very transparent about the uses. In the commercial context, that's very important. Of course, there are many good reasons why you wouldn't want to be too transparent with individuals about the use of their data in other contexts, such as law enforcement or anti-fraud prevention. And the UK Data Protection Act is broad enough to make provision for those circumstances. But in some cases, when it comes to the use of big data, the use of social networking information, the more objectionable an individual might find that processing, the more important it is to be transparent, to let them know what you're doing with data. And we see a lot of, that there is research out there to suggest that individuals are keen on what we might call a data dividend. In other words, if they're going to give some of their information to an organization, they want something back in return, and whether that's assurances about how that data is going to be used, whether it's some sort of incentive to use that slightly intrusive information, such as location data or information about their shopping habits, for example. They are much more likely to interact and to be comfortable with that. Of course, jurisdiction makes a big difference here. Some of laws about what you can and can't do with data are very different. So therefore, the expectations in terms of the law might be very different. But as we've seen from the data protection implications here, the data protection principles here in the UK, which are very much those sort of common sense principles, I think they encapsulate what you would expect most people to accept is a reasonable level of privacy and understanding in the use of their information. And of course, the more sensitive the data that is being used, the more important it is to build that trust and to be transparent. Here in the UK, examples of where big data might be used could be in healthcare, identifying trends around illnesses and potential treatments. Well, obviously, if people's data is going to be involved in that kind of research, and there are good reasons why it might, then obviously you'd want to be transparent about it if you were going to use that information, so that people know what's going on with their data at all times. And really, that is the core principle of data protection in the UK, the transparency. You might call it a sort of cards on the table approach, in other words, declaring what you're doing with information. And that's a real challenge, I think, for organizations that are starting to use data in new ways. And obviously big data is one of these concepts where you actually might not know what you're going to do with information when you gather it. One of the fundamental points of transparency is that you tell people what you're doing with their data at the outset. That can be challenging if you suddenly gather the information and find that there are new ways to process that data as you find them and as your capabilities grow in terms of the analytics that you can perform and the software that you're using to do that. So that's a major challenge, is keeping the trust of individuals and ensuring that they're aware of what you're doing with their data. What we need to see, again, are more transparent and more creative ways for organizations to deliver that kind of message. Here in the UK, there's a lot of discussion around terms and conditions about what you give to an individual in terms of information about how you use their data at the outset. And that sort of binary agreement delivered at the outset in terms and conditions that can be very lengthy and perhaps misunderstood or not even read by individuals is not really something that's going to be conducive with a new way of processing data in more complex ways. So the best practice suggestions here would be to start thinking about new ways to tell people what you're doing with their information, whether that is just as they're downloading an app, giving them the necessary information at that point to ensure that they are fully clued up on what's going to happen with their data when they press that button, or what information is going to be gathered from that action, or whose profiles they're going to access if they log in via social network. A variety of new sort of privacy issues are coming about, and it's really important that organisations start to use new and innovative ways to deliver that kind of information rather than just the binary terms and conditions. Of course, as I've mentioned, analytics will not always use personal data. There won't always be that element to it. So it's sort of wider uses of information, not necessarily going to come under the scope of data protection here in the UK, because, as I reiterate, the data protection laws cover information that relates to identifiable individuals. And personal data in the context really of big data can be gathered in several ways. It can be provided, that's usually consciously, by individuals when, for example, filling in online forms or applying for a product or service. It can be observed, recorded automatically, and here in the UK, a classic example of information that is recorded automatically and observed would be from closed-circuit television cameras, for example, that might be linked to facial recognition, which gather data about individuals as they potentially go about their daily business in public areas, or indeed within the workplace. So you start to see how there can be a slightly more intrusive element to that. It can be derived, which is essentially data produced from other data, like, for example, calculating customer profitability from the number of visits to a store or the items purchased by that individual. And again, we're starting to get into the realms of inference and of making decisions about people based on information that they're generating. And it can also be inferred using analytics to find correlations between data sets and categorizing those and making sure that you're categorizing certain individuals based on a mathematical profile. This is what we start to see more of with big data, and some of the stories that you hear or complaints that you might hear about the uses of big data are where individuals have perhaps decisions have been made about them based on information that is gathered elsewhere about other people. There was an example of a man in the United States who he'd been married very recently, went away on honeymoon, came back, and his credit limit had been reduced dramatically by around $7,000. And when he asked about this, the credit company said, well, the likelihood of people that shop in the same sort of stores as you is that they are going to fall behind on their credit repayments. So decisions being made about an individual were based on the behavior of others. And I think you can see there that a lot of the possibilities with big data are really starting to find out mathematical modeling about what people might do based on correlations within data. And that's a key point within big data, I guess, is that it's very much correlations. You might not actually know what it is that you're looking for at the outset. You've just got more data and more capabilities of going through that information. And as you can see, as I mentioned earlier about transparency, that's always going to be a bit of a clash, the idea of openness and transparency when it comes to uses of personal data. Anonymization is a key concept that could work in the big data context. It is more challenging, but essentially anonymization, if done properly and securely, would render the data falling outside the scope of the UK data protection laws. That's because, again, I mentioned that it's identifiable individuals that the law covers and data about those. So if data is fully anonymized and you've got a data set that you might be using for research purposes. You've got data maybe that shows migration patterns through shopping centres if it was derived from mobile phone data. If it is not actually identifying individuals, it can fall outside the scope of the Data Protection Act, and that here in the UK and elsewhere with data protection laws that are similar, can very much be a tool to help big data analytics, because if you don't need to identify people, then there's a lot that could be done to process information outside the scope of the DPA. Of course, there are dangers with anonymization. Some of those might be that you can introduce other data that would make it possible to re-identify individuals from data that had previously been anonymized. So there are dangers to look out for there for UK data controllers and for anyone that's hoping to use anonymized data because it doesn't identify individuals. And the ICO has recognized that there are issues here and has mentioned that has produced a code of practice that covers anonymization and techniques that might be used to render data sets anonymous. That, again, is available on the ICO website as part of our suite of guidance. And it's probably worth mentioning that new data protection regulation I mentioned at the outset really looks to build in these sort of concepts, the idea of anonymization, for one, because the lawmakers in Europe envisage that that will be a positive privacy protection element. And so it says in the regulation, as it's currently drafted, and there's by no means any guarantee that it will come through as drafted, I should add, but it looks at anonymization as a really good concept of privacy enhancement and what we call a privacy enhancing technology. And it says that if you can use data in an anonymized format for as long as possible, then that's what you should do. You should hold it in that format. A lot of complex discussions going on around that. I've mentioned the data protection principles, and let's look at those in relation to big data. The fairness point in the transparency is obviously very important, and when measured up against what might happen with big data, we've got to look at that in terms of what we might call creepy analytics. In other words, finding out quite a lot about people that they may not be aware is going on. That level of information, that level of analytics, and fundamentally, you need to look at what people are told when that information is gathered about them. So this is the sort of advice that we offer to data processors, well, that is organisations that process data here in the UK, and the same is applicable across Europe, who have data protection laws that are taken from the same European directive and are versions of the same directive. They're all very much similar in terms of what the sort of protections that they offer individuals, and the expectations of individuals and the effect of the analysis are really important. At the ICO, we receive complaints, as I mentioned before, from people who feel that organisations have breached their information rights. Well, a lot of the confusion and a lot of the concern comes from basically a use of data that goes beyond the reasonable expectations of an individual. And if they had given permission or had been given the option to provided permission for those uses, may not have done so because they would have found them objectionable. Importantly, it's the effect of the analysis on that individual that we would look at. So if the ICO does go to the point where we're issuing fines, we're always looking at what was the impact on the individual. And the more difficult or the easier it is to see that organizations are processing data in a way that could potentially have a detrimental impact to individuals, the more likely we are going to move to a fine situation. And that's obviously going to happen where there's much more there's much more sensitive data at stake, be it health data, financial information, for example, or any other information that could be considered sensitive. Obtaining meaningful consent, therefore, becomes a really important concept in data protection terms. So if you need to justify your data use by getting the consent of an individual, then you really need to make sure that that's clear, and particularly when there's more intrusive data use happening. So, for example, going back to the health, potential use of health data, you would expect if there are any processing concepts going on and schemes going on that involve the use of that data, then there would be an element of consent involved in the gathering and using of that information. There are various ways that, again, here in the UK, you can gather that justification for processing. It might be contractual obligation. It might be in the legitimate interests of the organisation. I mentioned before the crime detection and prevention or anti-fraud. There are obviously times when it is in the legitimate interests of an organisation to process data in a way that an individual might find objectionable. Obviously, if you're trying to protect revenues by countering fraud, then the would-be fraudster is going to be concerned about that. But the law is set up in such a way that there is a balance to be found between the interests of the organisation and the interests of the individual. Data protection is not all about ring fencing. It's not all about information security here. It's very much about the flow of information. It's about having a legitimate framework to share data within that is suitable for economic benefits, but also for the principles of privacy for individuals as well. And the law seeks to find a balance there. Some of the concerns about the new data protection laws in Europe that I've mentioned, some of the lobbying suggests that that level of control might fall a little bit too much in the hands of the consumer. It remains to be seen how that happens, but we've always said that organizations should have a legitimate reason for needing to process data, and I think that will be clear as the sort of information age and data protection becomes more prevalent where big data is involved. You've got to, again, think about purpose limitations when using data. One of those principles is that you've got a specified reason for using data, and when you're gathering that information, you want to be specific about what's going on with it. So it's really important that those purpose limitations are followed. But this is one of the key challenges with big data here in the UK, is that organisations are saying we don't know what we're going to do with that information when we actually gather it. We are getting new capabilities all the time. How do we tell people what we're doing with their data once we've gathered it? And this is a big challenge. To hit transparency requirements, you're going to have to interact with that consumer if you're looking at new ways of processing data. Data minimization, a key concept, only using as much data as you need. That's one of those data protection principles against an equation that has been brought out in relation to big data of n equals all. In other words, when you have a specific task that you're looking at, you know what data you need to look at to achieve your task. With big data, it's much more about algorithms. It's much more about let's use all the data we've got to see if we can start to find correlations and patterns of behavior. We might not necessarily know what we're looking for at the outset, but let's just use all that information. And that challenges the data minimization principle of data protection. SARS means subject access requests. Does it make it easier or harder? This is perhaps something a bit specific to UK and European law indeed. But this is the concept that individuals have a right to see the information that is held about them by an organisation. So they have a right to make a subject access request, or SAR, to an organisation and say, I want to see the data that you hold about me. Does big data make that easier or more difficult? Well, if you think about the fact that you're going to be dragging more information back that might or might not be related to that individual, it's potentially going to make it much more difficult to return information to that person. But if we're talking about electronic processing, then there's an argument that to return that data and to pull it from the system might become slightly easier than currently what we see is an organisation having to find data that is contained within hard copy information or on legacy systems. Tools for compliance. Well, here in the UK, we very much promote the privacy impact assessment approach. It's basically a based on risk assessment methodologies, standard risk assessment methodologies, but looks at the use of data very much in privacy terms, and we do encourage organisations to carry out one of these assessments. It gives you the opportunity to look at data and the uses of data by going through all of those principles, but also by thinking about some of the other key data protection elements and how that processing might look to individuals. Would they find it objectionable? What happens if the press, for example, get hold of a story about what you're doing with data? Does it look intrusive? Is there a justification for doing it? And that's what we would suggest all organisations that are undertaking a project that involves processing data. That's what we suggest they think about and look for. Baking in privacy by design. That's another key concept. Really making sure that where new processing is coming about, that you look at the privacy elements, whether that's extracting data for subject access requests, or whether that's making sure that the transparency is in there. By making privacy a priority at the outset, it really helps organisations to comply later down the line. And transparency. I've mentioned there that privacy notices or terms and conditions don't necessarily work with analytics and big data, or that's what we're being told. Yes, it's a challenge, but it's still something that needs to be overcome because the data protection law as it stands is still in place, and it's very important that organisations comply. Some of these concepts, again, just going back to the evolution of data protection law here in the UK and wider European context, they are going to be given some legal recognition. So we'd consider these to be good practice right now. In other words, there's no obligation to carry out privacy impact assessment or to build in privacy by design, but they are good practice ideas that we very much advocate. The new regulation that could come into play looks to give those concepts legal recognition, which we think is a very positive step in terms of privacy. So I've mentioned the Data Protection Act has been challenged as not fit for purpose. Well, we would argue that it is. It's flexible in the principles. Okay, it is dated, and we do agree that it needs to be updated, and the review of it has come at a good time. But there is flexibility there. There is a necessity for the Act to be less prescriptive, perhaps, than organisations might feel it should be, because we don't want to be setting the rules about what you can and can't do with data in every context, in every sector. There are organisations and very good data protection officers within these organisations that know what the rules are and they know what it means to them in their context. And we would much rather, as a regulator, be more of an overarching view, rather than be the sort of regulator that is very prescriptive and telling organisations exactly what they can and can't do. Data protection challenges big data players to innovate, to think about new ways of getting their messages across. And all of this, whilst innovation happens at a breakneck pace, obviously we're talking about concepts that are being promoted, that are being built into products and services, and are being used because there is a genuine desire for them, be that from consumers or from organisations. So we are aware that a lot of the technology and a lot of the innovation is really driving the new concepts and the new ways that data is used, and the law is sort of struggling to keep up in some ways. But where those challenges are, the law still remains, and organisations really have to be, understand that it's not all about privacy being dead, people are concerned about privacy, and that they like the fact that there is a legal framework in place to protect their data. And even though the ways of using that information are innovative and it becomes a challenge to work within that framework, it's still a challenge that needs to be met. We're seeing much more the role of third parties involved. The more data that is produced, the more likely it is that third parties such as data brokers are going to be involved in using that information, potentially analysing it for the benefit of individuals. We've got lots of schemes, a government-run scheme actually here in the UK called My Data, which looks to hand control back to individuals in terms of the uses of their information, be it banking data or their purchase data. And this concept is, I think, gathering pace. The idea really that organisations will step in and act as sort of personal data services, but we're also seeing it in terms of accreditation and third parties perhaps looking at and auditing organisations on their uses of data and coming up with sort of accreditation schemes. We are very heavily involved in one such scheme here in the UK, which looks to providing data seals or privacy seals, which are essentially a kite mark, an easy way for an organisation to display that they have hit certain standards of data protection, and they can show these kite marks on websites, wherever it might be, to consumers who can at a glance see that they're hitting certain standards when it comes to the uses of data, and might give them an inclination to interact with those organisations. I've mentioned the regulation throughout this presentation, and many of the concepts of big data are really being tackled by the regulation. There's a real genuine appetite to get this new data protection law through here in the UK. It's been 3 years in the making, just gone past the 3-year anniversary of the first proposal, but it's no surprise that it is much debated and much talked about. Data protection laws, we really want to get them right, and it's there are lots of organisations out there, many of whom have grown up within the time frame of this particular piece of legislation being in place. Classic example being credit bureau that have become data processing, huge data processors, and data is essentially their business. It's a very mature market here in the UK, but there is a lot of data used there. So obviously when we're starting to talk about some of the key prospects, the key tightening up of law here, that's a particular industry that is very, very concerned with how the data protection laws will look in the future, because it might alter the way that they actually operate their businesses, and it's very important that they've got a say, and that we get to a point where the law not only suits organisations such as those, but also individuals, because clearly there's a lot of processing that goes on, perhaps you might say behind the scenes, that actually helps individuals rather than hinders them, and so finding out more about those and how they operate is a real challenge for us at the ICO. We're often talking to consumers who want to understand more about how the data is used, and credit bureaus, credit reference agencies have always been one of the major industries and talking points for us. I know we're getting very near to the end, so again, recap: building trust and being transparent, very, very important. We're seeing examples of trust-based approaches and commercial drivers for it. Organisations are keen to show that they're good with data. Organisations also concerned with data quality, and they want to build in data protection. As I've mentioned, the credit bureau and the credit reference agencies here in the UK, it's a key industry in terms of the quality of data. If they're going to start using big data, one of the key data protection principles, of course, going back to that original slide, is that data has to be accurate and up to date. Obviously, the more accurate and up to date the data, the much better it is for a credit bureau, and particularly organisations like lenders who are wanting to make decisions about people. They want to be doing that on the basis of a quality report that is accurate and gives them the necessary overview of the particular risk that they're assessing in terms of the individual. And I think what we've seen from our research is that organizations need to be realistic about the benefits of big data and be open with what they're doing. We don't want to see organizations just starting to hoard information because they think they might use big data in the future, or you think that there could be a brave new world out there that they don't want to miss out on, so they're starting to gather information. And we would always say that keeping data just in case is a bad policy here in under UK and European law, because if you lose that information or something happens to it, you're still going to be liable for action, enforcement action. So it's very important to make sure that you're only using what you need to. But I think big data again might challenge that, because organisations are going to want to keep data, thinking at some point in the future we could derive some monetary value or some insight value from that particular data. So it's very important to keep check on that. You can go to the ICO website to find out more. We have a newsletter that you can subscribe to. That's a monthly newsletter that brings out a lot of the key data protection and freedom of information issues. But we can also be contacted on the usual social media networks and YouTube as well. I've got some videos on there showing some of the key data protection concepts. I hope that has been useful. I understand, again, apologies for the late start. I might have truncated slightly our opportunities for questions, but I think you will have the slides available to you shortly.
Thank you, Alastair. We're okay for a few minutes for questions if anybody has any. Please feel free to come off mute or, as I said, to type in the chat box. Can I start with a question?
By all means. Yeah.
You mentioned the kite mark. Is this something that you're just working on in the UK, or is this something that's European-wide, even worldwide?
Yeah. I think in the longer term it will be European-wide when it's got the recognition. Again, this is another thing that will get recognition within the regulation. So all member states will be working towards the same law and with a regulation, slightly different to the way things are now with the directive. But so it will gather that world sort of international recognition within Europe. At the moment, we're working at it at a UK level. Looking at sort of UK organisations. We're not quite sure about the scope of it yet. We're doing a lot of research into whether it should be an industry-wide issue or whether it can be applicable to all data controllers in a range of industries. But I think it's something we'll see more of. I know that data protection authorities across Europe are very keen on this kind of thing, and hopefully it will, it will be a very useful tool in helping individuals understand what's happening with their information.
Thank you. Does anyone else have questions?
Just a brief comment. Thanks a lot. Great stuff.
Okay, you're welcome.
I'm very pleased that you took the time for us. It's important. My name is Reynir. It's important for us to understand things from your side as well.
Yeah, thank you. And we're really keen to work with industry. And as I mentioned at the outset, we'd much prefer to provide our view and how we see things in relation to what is acceptable, legally acceptable, because I think that just makes for a better discussion, a better interaction between regulator and organisation, and subsequently organisation and individual. So, we're always happy to talk things through and provide advice on where we see the danger areas before you get that sort of regulatory enforcement action. That I think in some data protection authorities are much more focused at enforcement, and perhaps the only time you'll hear from them is when something's gone wrong. But we prefer to be a little more pragmatic.
Just quickly, Alastair, you mentioned when we were on the phone that you also work with other countries, sometimes to advise like countries which don't have regulation already.
Yes.
So, as I said, I know some of the countries we're working in don't have regulations as such. The newer countries we're starting, so maybe, as I said, we can look at them.
Yeah, that's. I mean, we have an international team here at the ICO who quite often have discussions with other data protection authorities within Europe, but also further afield, and countries that are just developing their information rights laws have been to see how things are done. Not always data protection, but I mentioned that we've got freedom of information laws as well, where I think government are trying to be more open and transparent, and we've seen a lot of interest in that model. But I think that in terms of the framework, the legal framework here, it's often been looked at as a good example. I think to perhaps other organisations that are looking to, other countries that are looking to implement data protection laws. Yeah.
Okay. Well, thank you ever so much for your time today, Alastair. As Raina mentioned, we're very grateful to hear it from the other side. The presentation will be available online very soon, and also people will be able to watch the webinar again. And don't forget, you can get in touch with the ICO and Alastair via the social media and email. Okay then, thanks a lot everyone.
Okay.
Have a good day. Thank you very much for today, Alastair. I'll talk to you again soon.
Okay, you're very welcome.